An agreement is binding contract between parties for sale and purchase of property. So while drafting an agreement to sell a property, it's crucial to include all pertinent details to ensure clarity and avoid future disputes. Here are some important factors to include. 1. Identification of parties, full names, addresses, and contact details of both the sellers and buyers, including any legal representatives or agents involved. 2. Property description, detailed description of the property being sold, including its physical address, boundaries, size, property number, Kawat, Katuni, and Kasra numbers, and any pertinent features. 3. Purchase price. Clearly state the agreed-upon purchase price for the property, along with the currency and any terms regarding payment, such as deposit amount and schedule. 4. Payment terms. Outline the terms of payment, including the method of payment, any installments, and deadlines for payment completion. Preferred mode should be through bank or electronic transaction fully detailed in the agreement, such as account numbers. 5. Earnest money/deposit. Specify the amount of earnest money or deposit, if any, required to secure the agreement, as well as the conditions under which it will be refunded or forfeited. 6. Conditions of sale. Include any conditions that must be met before the sale is finalized, such as obtaining financing, satisfactory inspection results, or the resolution of any legal issues related to the property. 7. Closing date. Specify the date by which the sale is expected to be completed, including any contingencies that may affect the closing date. 8. Title and ownership. Clarify the current ownership status of the property and ensure that the seller has the legal right to sell it. For this, it is necessary that a attested copy of sale deed or fard bay be obtained. Also outline the process for transferring the title, time, date, and place for such transfer and any warranties or guarantees regarding the title's validity. 9. Property taxes and liens. Disclose any outstanding property taxes, liens, or encumbrances on the property and specify how these will be addressed during the sale process. 10. Closing costs. Detail which party will be responsible for various closing costs, such as attorney fees, transfer taxes, title insurance, and any other expenses associated with the sale. 11. Contingencies. Include any additional contingencies or conditions agreed upon by both parties, such as the sale being subject to the buyer obtaining satisfactory financing or zoning approvals. 12. Signatures and date. Ensure that the agreement is signed and dated by all parties involved, as well as any witnesses or legal representatives, to signify their acceptance and commitment to the terms outlined in the agreement. The name of the scriber of the agreement must also be written. By addressing these important factors in the agreement, you can help safeguard the interests of both the buyer and the seller and facilitate a smooth and legally binding property transaction.